right, good morning, good afternoon, ladies and gentlemen. We are going to begin with our Fulton State Expedited Accusation Calendar. This is for today, November 11th, 2022. My name is Judge Law, and I just want to let you know that these are cases in which individuals were recently brought to the Fulton County Jail. Upon being booked in, the Solicitor General's office has already accused these cases. So therefore, this would be the defendant's initial appearance before a state court judicial officer. When I call your case, I'll be giving you some information, namely, what is the formal accusation number? What are the charges brought against you? Who's going to be your attorney? And what is your bond with regards to your charges brought against you? Some of you already have preset bonds that may have been set by the judge issuing the warrant. In other cases, I may readdress bond. If you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything you say about the facts of your case during the course of this virtual recorded proceeding, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Do we have conflict counsel here today, by any chance? No conflict counsel?
Good afternoon, Your Honor. I'm here.
All right, excellent. Thank you. All right, let's begin with courtroom 2. Courtroom 3. Sergeant, good morning, good afternoon.
Good afternoon, Judge. I just looked at the calendar and I have Ms. Williams here and she's not on the calendar.
You're correct. She is not. We thought she had bonded out or something to that effect.
Your Honor, if I may.
Yes, Ms. Falk.
Yes, we filed an NOD on that case and did send that to the jail as well as to Mr. Wilburn and filed it with the clerk.
Okay, does she have any other matters holding her at the jail?
She does not, of which I'm aware. I've looked at her booking record. This was the only charge.
Okay. Sarge, that was the only case against her, so she should be processed for release.
Okay, thank you all so much. Have a good day.
Thank you. All right, let me see. Courtroom 2, who do we have, please?
Yes, good afternoon, Judge Law. Surprisingly to see you on a Friday. This is going to be position number 11, Ms. McCamey.
All right, thank you. All right, and let's see. Ms. Nicole McCamey is charged with theft by deception from May 20th, 2022 in case number 22 CR 007722H. Ms. McCamey, you've been advised of your right to remain silent, and your attorney is going to be, who is her? Oh, Mr. McLean, there he is. Sorry about that. Okay.
Here I am.
I see you. Okay, thank you. Your attorney is Mr. Michael McLean. Do you see him on the screen? Okay, good. Mr. Tucson, any priors?
It's a third adult arrest, 2019 simple assault trespass conviction. 2015 trespass, simple battery, not prosecuted.
Okay.
First cycle was juvie.
Understood. Thank you. Ms. Anderson, good afternoon. What is your bond recommendation for Ms. McCamey?
Good afternoon, Judge Law. The bond recommendation is $3,000 signature bond through pretrial services, a no further contact, and a stay away from AR Financial Services.
All right, that will be granted. Ms. McCamey, I'm going to grant you a $3,000 signature bond. With no objection from the state. It will be through pretrial services, which means that you would have to report to pretrial once a month and not get into trouble with the law again. You also make sure that you do not contact any of the staff or the business known as AR Financial Services, Inc. And your next court date will be sent to you at your current address. And I hope we have your current address. I have a Milford Chase Court. Is that your current address? All right. Make sure you keep a lookout for that address. You might also want to reach out to the public defender's office to see and re-qualify yourself to see if they will represent you in future proceedings. Otherwise, you will have to hire a private attorney. All right. Thank you.
Your Honor, if I may, I just wanted to make sure the public defender's office has been filing entries of appearance in these cases. I wanted to make sure that was done in this case.
I don't see one.
Okay. I will make sure to reach out to Mr. Howard and ascertain why
Your
that.
Honor, yes, our office is filing entries of appearances after today, so it's not going to be done prior to this court hearing, but everyone who qualifies will have an entry of appearance filed shortly after court ends.
Okay, then would they have to requalify themselves in the future?
We're qualifying them from today's calendar. This individual does qualify.
Okay, perfect. Thank you.
Thank you. And Your Honor, just going forward, if they can indicate whether the defendant does or does not qualify, so we can be sure whether they are filing an entry.
Sounds good. Thank you.
Thank you.
All right,
Order.
court 2, we'll have the next, yes, Ms. McLeod?
Yeah, I was here for Miss Williams, but since her case has been NOD'd, I have no other matters. So may I be excused?
I believe so. I don't know of any other conflict cases. So yes, thank you, Ms. McLeod. Enjoy your weekend.
Welcome,
Thank you.
Judge. Thank you. Same
Mhm.
to you.
Hey, Judge, this is Melissa. Can you give me the conditions again, please?
To report to pretrial, once a month, do not get in trouble with the law and stay away from AR Financial Services, Inc. All right, moving on to courtroom 2, what number was this?
Yes, Judge, this is position 9, Hogan's, and he also has a father, his parent is here in the gallery.
Thank you. This is Quintarius Hogan's with an S, charged with simple battery, domestic violence from February 14th, 2022. Mr. Hogan's, you've been advised of your right to remain silent, and I believe that your attorney is going to be Mr. McLean. Mr.
No, Your Honor,
McLean?
it'll be me.
Oh, I'm sorry, Ms. Counts. Okay.
Yes.
All right, and Ms. Counts, not to repeat myself, but he does qualify, and the public defender's office is going to continue representing him, correct?
No, Your Honor, he does not qualify.
Oh, okay.
And he has been
does not
informed of that.
qualify. All right, are you representing him for this?
Just for the
proceeding?
purposes of bond today, yes, ma'am.
Okay, all right. So he does not qualify. So Mr. Hogan's, after today, you will have to go and look and hire your own private attorney because you do not qualify for the services of the public defender's office. Do you understand?
Yes, ma'am.
All right. So in the meantime, Mr. Tucson, any priors?
Yes. Hold on.
I see he has 2 open cases with us.
Yeah, he 11 total. Last arrest was on the 7th of this month for misdemeanor possession of marijuana out of East Point. Open case 21 CR 004 308J for DUI obstruction. Failed to report striking fixed object. Got a 22 CR 005 736J. Simple assault, public drunk. 2015 simple assault. He had a failure to appear from 2013. I put that in the chat for you.
All right.
I
Thank you.
missed that one. 2011 obstruction. It was dead docket. That's it.
All right. Thank you. All right. Ms. Duncan?
Good afternoon,
Yes.
Your Honor.
All right. And what is your bond recommendation for Mr. Hogan's?
In this case, the state's bond recommendation is a $3,000 surety. No further contact with the victim in this case. Her name is Katie Quarterman. That's Katie, last name Quarterman. Third party child contact for the shared child that they have together. This incident location seems to be, I don't know if that is the victim's address. However, we'd ask for her to stay away from the incident location of 505 Fulton Street Southwest, that there be a 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. This case did occur on, this incident did occur on February 14th of 2022. The defendant in this case is accused of slapping Ms. Quarterman in the face in front of their child, who was 9 years old, because she made a statement to him saying that she wished she had a different baby daddy. She said that this is not the first time that he's struck her and that he struck her in the past. However, our victim advocate did indicate that we spoke with the victim and she no longer wants to pursue the charges since then. But given the incidents as alleged, and they talked to the child involved, she did see the strike happen, and she stated to officers that he slapped her mother in front of her, and her mother tried to immediately push him off. initially the victim did have concerns about a TPO. So given the facts and circumstances in this case, Your Honor, and that this defendant does have an arrest that I believe pre-trial put to you in the chat, that is a violent offense, and the previous FTAs, we do have some concern about the risk of reoffense here, given the violent nature of this defendant's history, and we have some concern about the flight risk given the recent FTA, so we believe that recommendation from the state is more than reasonable. Nothing.
All right, thank you. Before we address the PD, did the parent want to say anything, or shall we just proceed with the attorneys?
Said yes, he's coming. He's here, Judge.
All right, good afternoon, sir. My name is Judge Lal, and I'm sorry we are appearing doing this virtually, but that's the nature of things. If you'd like to add anything, I need to place you under oath. Is that all right?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am, I do.
All right, sir. That is your son?
Yes, ma'am, it is.
All right. Unfortunately, a rather troubled history in the recent past.
Well, he have a little bit of trouble here, but he been doing really well. You know, the situation happened in February, and this is the first time that we got notice of it when he was on the way to work. He took it upon himself to, I guess, smoke or something like that, and on the way to work, and he got apprehended by the model police. And had it not been for the model police, we would have never known about this situation at all. But my granddaughter's mom and I and him, we have all sat down and discussed all this and got all this taken care of. So he knows himself that his relationship with her is non-voided right now. He just deal with his daughter accordingly and be finished with all that. Other than that, he's working good. He's doing the right thing and stuff like that. And again, Your Honor, had we have known about this, him and I, we would have been and went to the court and tried to address this situation. This is the first win that we got of this. And I wouldn't be here if I wouldn't have confidence in him that doing the right thing.
Thank you, sir.
Thank you.
You may return to the gallery, please.
Thank you,
Thank you. Ms. Count, what's your recommendation?
Yes, Your Honor. My client does have a separate address of 860 Grant Street, so there wouldn't be a problem with a stay away from the incident location. I would say that he does not qualify for the public defender due to his income. However, he does provide full-time support. He's not on child support. He does provide full support for his 9-year-old daughter that he does share with the alleged victim in this case. And because of that care, I would ask for a signature bond or a bond of the lowest possible in order for him to continue to provide that care to his child. Other than that, Your Honor, I would leave it into your discretion.
All right. Mr. Hogan's, your bond is going to be set at $2,000. It is a surety bond. You do not qualify for a signature bond at this present time. You have multiple cases open, at least 2 right now. And I'm not surprised that your parents don't know about this, but reading the warrant, it appears that you were not at the scene when the police arrived. So that's something that you're going to have to deal with in court through your attorney. And I do hope that you do hire an attorney. It's a $2,000 surety bond, no contact with Ms. Quartermain, and to stay away from wherever she happens to be, whether it's at her home, at her place of work, whether she's walking on the sidewalk or at Marta. If she's in that location, you have to turn around and walk away. You're not to have any communication with her in person, through a third party, through a cell phone, computer, or even on social media. It appears that you do share a child with her. And if you like to have visitation and joint custody with the child, you would need to file the appropriate legitimation action with the Superior Court and get a court order to establish your visitation and custody rights. Do you understand?
Yeah, ma'am. All
right. Your next court date, Ms. Grace, is that going to be December 1st?
Yes, ma'am.
All right, your next court date is December 1st. If you do make bond, we will send you notice of your next court date to your home address. And in the meantime, when we bring this case to December 1st, we're going to bring along the other two cases. Miss Grace, do you see the two cases listed on the calendar? His DUI case and the simple assault case. It's listed
Yes,
on the
ma'am.
calendar. We're
Yes,
going to
ma'am.
bring all three cases to the SAP calendar. And then we will address it accordingly. Thank you.
Judge, what was the bond amount, please?
2,000 surety.
Thank you. All right, you're done. Position 2, Mr. Alvier.
Good morning, Your Honor, again.
Good afternoon. This is State
Good
versus
afternoon.
Mohammed Alzier, case number 22 CR 007724G. Mr. Alzier is accused of theft by taking from November 19, 2021. All right. And Mr. Alzier, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And Mr. Tucson, how many cycles, please?
31 total. He got an open robbery by force, theft by taking, 22 SC 184010. Last arrest was in August, FTA and probation violation out of Gwinnett.
All right, thank you.
He got a White County hold too. I think it's White
I
County.
saw that. Is it traffic?
Not sure.
All
Your
right.
Honor, he has an explanation about the White County hold.
Okay. And Ms. Anderson, what's your recommendation for Mr. Alzier?
The recommendation is $1,000 surety bond, a no further contact with the victim, who is Maya Thurman, MAYATHURMAN, and a stay away from the address of 5475 Windward in Alpharetta in Fulton County. Your Honor, on November 19th, 2021, the defendant, Mohammed Alzier, along with another person named Ali Festa King, Festa King, stole Maya Thurman's cell phone from the Burger Fi restaurant at the address provided in Alpharetta. And the incident was captured on closed caption television. Because of the open cases and the hold, the state asked for the $1,000 surety bond.
And the hold is out of Conyers. This is for larceny.
Okay.
All right.
Conyers, and that's for larceny. Okay. Mr. McLean, any objection to the $1,000 surety bond?
Your Honor, we would like to ask the court to consider a signature bond. Due to the nature of the offense, there's a co-defendant. A careful reading of the police report taken just upon itself, assuming the police report were true in and of itself, Your Honor, the facts don't indicate anything other than that he was there, and that Ali Festa King took something, and he couldn't have known that that was about to happen. He has an explanation about the, not that he has to give one, but he wanted to volunteer an explanation about the matter on the hold, because on my paperwork, the Fulton County hold shows White County Sheriff's Office, which is Cleveland, Georgia. He had a problem. He went to rehab. He has a certificate, or is trying to get their certificate to prove that he finished his rehab. And that's what the hangup is about, is somebody's missing a certificate showing completion of rehab. He is ambitious in that he's about to get a job. He has a 2-year college degree, bachelor's in business administration, not bachelor's, associates in business administration from the University of North Georgia in Dahlonega. He has no children, and he is hoping for a warehouse or a cooking job next. So he's going to be applying to warehouses and to restaurants to do one thing or the other. So he would like to ask the court to consider, given the nature of the offense, a careful gleaning of what the allegations are in the police report and his overall situation. He would like to ask for a signature bond.
All right. He's got 2 holds and he's got an open felony case for robbery by force. And considering these along with the allegations set forth in the warrant, I think $1,000 is the most reasonable bond. It's $1,000 surety. Next court date's December 1st. No contact with Maya Thurman and I don't remember that other person. Was it Alicia King?
Allie, ALLIE, Festa, FESTA-King.
Ellie Fester King, all right, and to stay away from the BurgerFi restaurant in Alpharetta, Georgia. Thank you.
Thank you, Your Honor.
Position 5, Duncan.
And I'm sorry, Your Honor, I don't know if Mr. McLean mentioned, but that individual did qualify. And so
No, he didn't, but thank you for letting me know. So Mr. Alzir qualifies for PD. Excellent, thank you. James Duncan is case number 22CR 007726E, accused of theft by shoplifting and criminal trespass from November 10th of 2022. Mr. Duncan, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Mr. McLean, he qualifies, yes?
it's mine, Your Honor.
Oh, Mr. Cox? Okay. Good.
Yes, and Mr. Duncan does qualify.
All right, good. And Mr. Tucson, 61 cycles?
Correct.
All right, I think that's good. Thank you. Ms. Duncan, I've read the warrants. Anything you'd like to add?
Yes, in this instance, Your Honor, he did go back to that location after receiving the criminal trespass case. And in addition to that, continued to steal toiletries. There is no preset bond in this case. It's currently being held without bond. The state is recommending a $2,000 total surety, $1,000 per count, a stay away from that target located at 2539 Piedmont Road Northeast. No alcohol, drugs, weapons, no further violations of Georgia law, and a theft class, because we believe it's reasonable given that this defendant does have several theft cycles. In cycle 12 in the GCIC, there is a theft by shoplifting. There's a theft by shoplifting out of Atlanta municipal arrest in 2001. There's an additional theft by shoplifting arrest in 2019, and in cycle 55 in 2021, there's an additional theft by shoplifting arrest out of Brookhaven. There's currently no disposition. We believe that this recommendation is more than reasonable, given the risk of offense presented in this case and this defendant's extensive history. Nothing further.
Mr. McLean? Oh, Ms. Cow, excuse me.
Yes, Your Honor. My client is unemployed, in between jobs. He has confided in me that he does have some health matters that he's not been receiving care for while in custody. Obviously, he has some liver issues. And he does have an appointment next week for a liver scan. And it is very important for him to make that appointment for his overall health and well-being. And so I would ask, I do understand that he has a lengthy criminal history, but I would ask, since this is a nonviolent offense, for your consideration of, instead of a surety bond, a signature bond of the same amount.
It's a long stretch, Ms. Count, 61 cycles.
I understand, Judge.
And he's younger than me. So.
I understand. I do believe that his challenges with employment would lend themselves to the type of offenses that we have here today. But again, I would ask for your consideration, namely because these are not violent offenses. Understood,
but they're repetitive. And that is what gives me even greater concern. On the theft by shoplifting is 1,000. On the criminal trespass is 500. Total bond is 1,500. It is a surety bond, and to stay away from all Target stores, not just the one on Piedmont Avenue. Every single one. Next court date is December 1st.
Thank you, Judge.
Position 15, Smith.
Your Honor, I will represent Anthony Smith today, and he does qualify.
Thank you, sir. Mr. Anthony Smith is accused of criminal trespass on November 10th, 2022 in case 22 CR 007731C. Mr. Smith, you are represented by the Public Defender's Office and you've been advised of your right to remain silent. Mr. Toussaint, I believe this was 33 cycles, if I'm not mistaken.
Correct. He's on
Right.
probation for burglary in the first. That should end next year. Last arrest was January 2020, trespass.
All right, got that. Thank you. Ms. Anderson, what's your bond recommendation for Mr. Smith?
The bond recommendation is a $5,000 surety bond with no contact with the victim, Angela Page. Page is Paige, and a stay away from Miss Page's address, 688 Gordon Place, Southwest, Fulton County. Your Honor, we will be asking for a transfer to the DA's office for entering auto based upon some additional evidence we received. I don't believe that was in the original warrant information. On November 10th, officers were dispatched to 688 Gordon Place on a criminal trespass call. There they found the victim, Angela Page, who indicated that the defendant was in her other vehicle, her BMW 325i, and the officers could witness him in the vehicle ducking down. He was arrested without any incident. However, he did leave a jug of urine in the back seat of her car. He also pulled out the hazard lights and a switch that locks the door of her vehicle. Based on the repetitive nature of his cycles dating back to 1980, Your Honor, and the high risk of reoffense, the state is asking for the surety bond of $5,000.
Mr. McLean?
Your Honor, the reason the public defender would rather ask the court to consider a signature bond is this is a perfect person for the PAD, for the PAD program. He has financial challenges, he has residential challenges, and he is very apologetic about the situation which led to his arrest in this situation, looking for a place to be warm. It happened to be a somewhat cold and windy night that night. I think it was 2 nights ago. If allowed to have a signature bond, he would repair himself to a shelter on Auburn Avenue.
Understood, Mr. McLean. Bond is set at 1,000. It is going to be a surety bond to stay away from 688 Gordon Place in Atlanta, Georgia, and no further contact with Angela Page. No alcohol, drugs, and weapons. And next court date is December 1st.
December 1st?
Yes.
Thank you.
Your Honor, for clarification, did you say a $1,000 surety bond?
Yes, I do.
Thank you.
Position 14, Simpson.
Marlon Simpson is accused of battery from November 10th, 2022 in case 22 CR 007730F. Mr. Simpson, you've been advised of your right to remain silent, and presently your counsel is going to be Mr. McLean. Mr. McLean, does he qualify?
Let's see, this place, I think Ms. Counts can tell me because we ran over the list.
He does not, Your Honor.
Right, thank you. Nonetheless, Your Honor, we are representing him today, and we do have a presentation to make.
All right. Mr. Simpson, the Public Defender's Office will represent you for purposes of bond today, but after today, you would need to make efforts to retain your own counsel because you do not qualify for the services of the Public Defender's services. Mr. Toussaint?
Third arrest, 2006 and 2020 DUI.
Thank you. Where is the 2020 DUI?
Hold on. Douglas County.
Okay. All right. Ms. Anderson?
Your Honor, the state is asking for a $10,000 surety bond. No contact with the victim, Kiera Williams. Kiera is spelled Kiera. No alcohol, drugs, or weapons, and a 1-day anger awareness class. The reason for the $10,000 surety bond, Your Honor, is mostly the Miss Williams' injuries. She sustained a black eye, a busted and possibly broken nose, and a bloody face. She was treated at the scene, and for disclosure, Your Honor, this was a dual arrest. But due to the extensive injuries suffered by the victim, the state is asking for the $10,000 surety bond.
All right. Mr. McLean?
I don't mean to sound whiny,
No, you never are. Don't worry, Ms.
but
McLean.
the
I'll let
what
you know
about,
when you are. Okay.
the whataboutism that I'm about to say is that, he got hit in the head with a bottle, and it was a dual arrest, and we would like to ask the court to consider a much, much lower bond, down to and including a signature bond situation. Alcohol can be a problem. Obviously, 2006 and the 2020, I think, was based on a 2019 incident in Douglas County. So Mr. Simpson and I have had a good conversation about Demon Rum, and he is determined to stop drinking and get on with his life. He does work. He takes care of his family, and in this situation, because of the apparently, at least initially when she was charged as a dual arrest, the apparent mutuality to some extent, we would like to ask the court for mercy on that bond.
Your Honor, if I may.
Yes, Ms. Ball.
I just want to point out the state NOD'd this case against Ms. Williams based on the allegations against Mr. Simpson. We do have some really serious concerns about the allegations in this case and how the Ms. Williams came to end up calling the police in regards to Mr. Simpson. We understand that her version of events was foggy because of alcohol, but we are continuing to investigate this case for possible referral to the DA's office.
All right, well, that's up to the prosecutor if they want to transfer it to or whether the district attorney's office will accept it as a felony charge. But right now it's a misdemeanor charge. Mr. Simpson, your bond is set at $2,500. It is a surety bond. No further contact with Kiera Williams. That means you have to stay 200 yards away from her. Do not communicate with her in any way, form, or manner, including on social media or through a third party. And you have to stay away from wherever she happens to live, work, or happens to be physically standing. No illegal drugs, no alcohol, and no weapons and no firearms. Your next court date is going to be December 1st. If you do bond out on the $2,500 bond, please make sure that your address, your contact address and information are current with us at all times, and that you report to court when summoned. Yes, Mr. Simpson?
Yes, I was gonna make sure my address is correct.
I can check and see. We have a Spring Hill Parkway address.
No.
All right, you might want to give your full address to Deputy Francois in the courtroom, and she will put that in the chat to our litigation manager, Melissa Grace. Thank you.
Position 16, White.
All right, Mr. White, your case number is 22 CR 007732F. You've been accused of criminal trespass causing damage to property from October 3rd, 2021. Your attorney is going to be Mr. McLean, and you've been advised of your right to remain silent. Mr. Tucson?
13 total. I got a simple battery conviction, 2017. 2012 criminal attempt to commit a felony, ag assault. The ag was a conviction. 2009 battery conviction. 07 probation burglary. Had a 03 robbery arrest. I'm not sure of the disposition.
All right.
And before
Thank
that
you.
was in the 90s.
In your honor, he
All right.
does qualify.
All right, thank you. I'm sorry, I'm just looking at something over here. All right. Okay, Mr. Anderson, what do you recommend? I've got a $500 bond right now.
The state is asking for a $1,000 surety bond, Your Honor, and a no further contact with the victim, who is Chiquita Jeanette McCoy. Chiquita is spelled CHIQUITA. Jeanette MCCOY McCoy. The factual basis, Your Honor, is that on the 3rd of October, the victim and the defendant were hanging out, excuse me, Your Honor, on the 2nd of October. The defendant and victim were hanging out and at her place, and she noticed the next morning on the 3rd that her phone was missing. She used the Find My Phone app and traced her phone location to the defendant's home. She went to his house, asked him for his phone, and he said he didn't have it. Finally, when she said she was going to call the police, he threw the phone at her and walked up the street and left. The phone does have some minor damage, Your Honor, but it does still work. Because of the extensive criminal history and the similar criminal history, the state is asking for the surety bond of $1,000.
All right. It's a $500 surety, and the reset date is December 1st.
Oh, Your Honor.
Oh, I'm sorry, Mr. McLean, sorry.
Yes. We would like the court to consider a signature bond because of the nature of the allegations, but in the alternative, actually, he and I discussed the fact that 1,000 surety would be through a surety company. Many times these bonding companies won't touch a $500 bond, and that leaves it up to family. I called his brother and I said, look, here's the situation. If the court's not going to give him a signature bond, which is what we would ask for, given the circumstances, how much harder is it going to be for you to come up with 500 because the bonding company won't touch it? So
he doesn't qualify because he's residentially challenged, and I'm concerned about his other open cases. So
understood.
So yeah,
his brother's.
I'll go with 500 or 1,000, whichever you want.
He's actually better off with $1,000, Your Honor. The family's going to try to do that.
$1,000.
It's an odd situation, but that's the way it is.
$1,000 surety bond, no contact with Shakita McCoy. Thank you.
Thank you.
Thank you, y'all.
You're welcome.
Position 12, Montgomery.
Oh, these don't fail me. Okay. All right, Mr. Barry Montgomery is 22 CR 007728F. And he's been accused of the following offenses from November 10, 2022. Driving on the wrong side of the road, reckless driving, and driving under the influence of alcohol less safe. All right. Mr. Montgomery, these are the 3 charges that have been brought against you. You have a right to remain silent as so advised, and you also have a right to an attorney, and your counsel is Mr. McLean. And Ms. Counts, does he qualify?
Mr. McLean, well, that's the only one he didn't get to me. Mr. McLean.
Oh, no, that was the one I called back about. Let me look at the let's see. Yeah, we'll get that in a minute, Your Honor, about the qualification.
Okay. While we're waiting then, Mr. Tucson, any priors, please?
9th arrest, last arrest was in March for hit and run, pled NOLO. 2008, he has a DUI arrest. 2005, 2016 DUI convictions.
Okay. Ms. Anderson, do you know what is the disposition of the 2008 DUI?
I have it as a conviction in 2006 and a conviction in 2016, Your Honor. I have a time expired on the 2008 DUI arrest.
Oh, I see. Okay. All right. And what's your recommendation for bond?
A $5,000 surety bond. The breakdown on that is $5,000 for the DUI, then a $1,000 for the reckless driving, and then $500 for the wrong way. So that's a total of $6,500. With no drugs, no driving, no alcohols, and no alcohol and no weapons. Yesterday around 4 o'clock, Mr. Montgomery was driving in and out of traffic and in the opposite lane, almost striking other motorists. The traffic stop was conducted, and a strong odor of alcohol emanated from the breath of Mr. Montgomery. He did consent to HGN field sobriety test, and all 8 signals for nystagmus were present. There were 2 open bottles of alcohol found in his Navigator, and they were taken into evidence. While at the scene, Fulton County Communications Operator advised the arresting officer that Mr. Montgomery has a Georgia major lifetime suspended commercial violation, along with a regular Class C license suspension. As pretrial told us, Your Honor, this is his second in 10 and third in life DUI, hence the $6,500 surety bond request from the state.
Mr. McLean?
Your Honor, we would ask the court to consider a lower bond than that, something in the nature of no more than about $4,000 for him to be able to make it. He does work and he does support his children, and he has substantial child support, which he does make his he does reach his obligations in that. He pays a good bit out of a high percentage of his income goes to his child support, so he is supporting his kids. So we would ask the court to consider something in the nature of something like 4,000 surety, if not a signature bond, which we would of course ask the court to consider.
So he's got 3 lifetime DUI arrests and or convictions, and he just got convicted of hit and run this year. And now this is his 4th DUI. On the DUI, driving under the influence of alcohol, that's going to be $3,500. The reckless driving, that's going to be $1,500. And driving on the wrong side of the road, that's going to be $1,500. That's a total of $6,500. That is a surety bond. No driving until further order of the court. It doesn't matter if the Department of Driver Services gives you driving privileges, Mr. Montgomery, as a condition of your bond. No driving. You will have to surrender your driver's license to the Department of Driver Services, and you may obtain it until the court grants you your driving privileges. You are not to consume any alcohol, no illegal drugs, no weapons, and no firearms. Actually, I'm going to do it this way. On the DUI, I'm sorry, Ms. Grace, I'm going to amend it slightly. On the DUI, it's going to be $3,500. On the reckless driving is $1,500, and driving on the wrong side of the road, that's going to be a signature bond through pretrial services. I'm going to require Mr. Montgomery to report to pretrial once a month and be subject to random screens for alcohol and or drugs. Mr. Montgomery, this is a very troubling traffic record. And if you don't take responsibility, you're giving us the option to take responsibility. And if you fail a drug test or if you fail an alcohol test, I'm authorizing pretrial to issue a bench warrant for your arrest, and we will readdress your case in court. Do you understand?
Your Honor.
You cannot afford to drive anymore. You cannot afford to have any alcohol, and definitely no illegal drugs. Unless you just want to stay in jail. Then that's a different story. Your next court date is going to be December 1st. This is a $6,500 split bond.
For Judge.
Your Honor, you said that $6,500 and that it's $3,500 on the DUI.
$3,500 surety on the DUI, $1,500 surety on the reckless driving, and $1,500 signature bond through pretrial on the driving on the wrong side. And that way we monitor him through pretrial and his alcohol intake as well.
So is that 7,000?
Is it 7,000? Did I do my math wrong?
You said
No, Your Honor, the 3,500 plus the 1,500 would be a total of 5,000 surety and $1,500 SOB for a mixed bond.
3, 4, 5, 6.
So 65. You're right, Your Honor.
All right, thank you.
Thank you.
Okay, you're done. I'll tell you. Position 10, McDuffie.
How you doing, Your Honor?
I'm doing well, thank you. McDuffie is position 10. Mr. Joshua McDuffie is accused of criminal trespass on November 10th, 2022. Mr. McDuffie, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. And
No, Your Honor, it'll be
Ms. Counts?
Right.
Okay, Ms. Counts, can we confirm that you that he qualifies?
1 moment. He does not. I'm sorry, he does qualify. He does.
All right, and with regards to Mr. McDuffie, Mr. Tucson, I've got 40 cycles. Do you have anything else to add?
You got an open felony, 22 CP 211612. Simple battery against police, battery, felony obstruction and disorderly conduct.
Hey, Bill threw that out, you know.
Before
I'm
that,
sorry?
he said hate bill, threw it out.
Yeah,
You gotta-
Mr. McDuffie, can you please, I want you to understand you have the right to remain silent, and so I'm here to speak on your behalf, so if you could just be quiet.
All right.
Thank you.
So that was an August arrest. Before that was July, DeKalb County trespass. April, shoplifting, possession of drug-related objects. February, failure to appear. June 2021, simple battery. You got an escape conviction as well. That's from 2019 out of Clayton County. 2018 probation burglary. That's 11 SC 98932.
All right.
You want me to keep on?
No, that's good. Thank you. Ms. Anderson, this is a criminal trespass at Georgia Tech. What's the state recommend?
The state is recommending a $1,000 surety bond, Your Honor, and a stay away from Georgia Tech, no alcohol, drugs, or weapons. He had already been told to stay away from Georgia Tech for 2 years. He was told that on April 2nd of this year. Only 7 months later, he returns to the campus and is arrested on this charge. Due to the multiple probation violations and failure to appear, Your Honor, the state is asking for the surety bond of $1,000.
All right, $1,000 surety bond, stay away from all Georgia Tech property. Next court date is December 1st. And Mr. McDuffie, yeah, unfortunately, your felony case is open and alive, still pending against you. And it's not been indicted yet, but it's an open active case. It's not been thrown out. Next case, please.
Come on.
I'm sorry, Francois, what position is that case?
Position 6, Gaskin.
Oh, 6, okay. Mr. Terrell Gaskin is 22 CR 0077277C, accused of criminal trespass as well, November 10, 2022. Mr. Gaskin, you have been advised of your right to remain silent, so please keep that in mind to avoid incriminating yourself. And you have a right to an attorney, and your counsel is going to be Ms. Counts. Ms. Counts, confirmed representation?
He does qualify, Your Honor.
Okay. And Mr. Tucson, I've got 26 cycles. Do you have anything else?
Yeah, got open shoplifting. That was from an arrest, I think from September. He went to the city for that. Probation in Clayton County for entering auto. 2019, they gave him 1 year to serve, 4 years probation. I also have theft conviction out of Texas. He has 18 cycles out of Texas alone. Range from theft to criminal trespass to evading arrest.
That's good. Thank you. Ms. Anderson, or Ms. Duncan, excuse me.
Yes, Your Honor, this incident did occur on November 10th, 2022 at the Peachtree Center MARTA station. This defendant is accused of having walked on the train tracks of that MARTA station after clearly being instructed by MARTA to not walk on the tracks because there are signs posted everywhere that says not to do that. And obviously that's very, very dangerous. This defendant did it anyway. The state has some concern here about the risk of reoffense. This defendant does have a criminal trespass no conviction from 2019. We also have some concern about this defendant's likelihood to positively respond to legal process, given that this defendant does have a probation violation from 2021, and the defendant is currently violating the probation that he's on, as pre-trial previously stated. This defendant also has other an FTA conviction from 2019 and a felony conviction from 2019. So we do have some concern about the flight risk. This defendant's case is currently being held without a bond, and the state is going to be requesting $1,000 surety in this case. Let's stay away from that incident location at the Peachtree Center MARTA station, located at 216 Peachtree Street Northeast. no alcohol, drugs, weapons, and no further violations of Georgia law. Given the facts, circumstances, and all other factors we believe are present in this case, we think that bond is more than reasonable. Nothing further.
And sorry, did you say the Peachtree Center Model Station?
Yes.
And it was allegedly found, okay, all right. Ms. Counts?
Yes, Your Honor. Mr. Gaskin has significant ties to Atlanta. He's been here since 2014. He does have a high school education. He is residentially challenged. He is seeking shelter at the Atlanta Baptist Mission Shelter. And last employment was several months ago. He did let me know that he could be contacted at the Atlanta Baptist Mission Shelter. So I would ask for your consideration of that. I understand the state is asking for $1,000 surety. I would ask for your consideration. I do understand his criminal history, but if you are going to consider his lack of income, then a signature bond, nothing further.
Well, it's not so much a lack of income, but the recidivism that always bothers me. Is the $1,000 surety bond to stay away from the entire Peachtree Model, Peachtree Center Model Station. So if you do use model services, you cannot embark or disembark at the Peachtree Center Model Station. Thank you.
Thank you.
Judge, what's the dollar amount?
1,000 surety bond.
Thank you. All right. Position 1, Adele.
This is Jonathan Adele, accused of harassing communications on or about May 26, 2022. And the case number is 22 CR 007720Y. Mr. Adele, you've been advised of your right to remain silent, and your attorney is going to be Ms. Counts. And Ms. Counts, shall we confirm if
Yes, Your Honor, he does not qualify for the services of the public defender.
All right, Mr. Adele, the Public Defender's Office will represent you for purposes of bond, but after today, you would need to retain your own attorney to represent you. Understood? Okay. All right, Mr. Howard, what's the priors on Mr. Adele?
It's first. He went to felony, he got a $40,000 bond. I think it was 20 and 20 on those 2 counts.
All
That's
right,
what I was just told.
understood. Thank you. Ms. Duncan?
Yes, Your Honor, in this case, it did occur as you stated on May 26, 2022 at 3101 Noble Creek Drive, Northwest in Atlanta, the home of the victim in this case, Gabrielle Richardson, both common spelling. The defendant was coming to her home repeatedly and speaking to her through the Ring camera that is posted in front of her property, making threats and making her feel uncomfortable, saying things that made no sense to her about her and killing his girlfriend and other things that Ms. Richardson was not comfortable with. She did indicate to our victim advocate that she believes that he may have been a squatter next door to her home. However, we believe that in this case, Your Honor, this defendant does have 2 open felony cases. It's aggravated assault with a deadly weapon and possession of a firearm during the commission of a felony, as well as a terroristic threat where he threatened to kill a person via voicemail. So in this case, there's a $1,500 preset surety bond. The state will be asking that that bond remain as set, given that the state believes that this defendant is a particular danger to the community and the citizens of Fulton County, and of particular danger to this defendant, the victim, given that it seems that he did not know her in particular, but felt the need to go to her house and make her feel uncomfortable and threatened in this way. We'd also ask for no further contact with Ms. Richardson and stay away from her address. No alcohol, drugs, and weapons, 1-day anger awareness, and no further violations of Georgia law.
Okay. Ms. Counts?
Yes, Your Honor. Mr. Adele does have a good address. He does reside at 3102 Noble Creek Drive in Northwest Atlanta. He does have 2 minor children, ages 7 and 5, that he does provide full-time care to. He is employed. He has good employment, and again, due to his income, would not qualify for our services. He has made it clear to me that he does intend to fight these charges in court, and so he will take the time to hire private counsel going forward. And so, based on this being his first time ever being arrested in his 31 years of life, I would ask for your consideration of his long length of law-abiding behavior absent this arrest, and ask for a signature bond.
All right, so this allegation apparently occurred somewhere in Noble Creek Drive. The terroristic threats charge occurred somewhere on or about Noble Creek Drive.
Yes, it was a different person.
Possession of firearm also on or about Noble Creek Drive.
Yes.
Seems to be an issue with that location. And the police ticket says that he's residentially challenged. So I'm a little
He
perplexed.
provided me the address. I asked if he had an address. Did he reside there? And he said that he does reside at 3102 Noble Creek Drive.
And our victim believes he does not, because the 101 is her home address. Whether
3101.
I have proof of the one being harassed is me, not them.
All right. Mr. Adele, that is quite a few charges, all stemming from the same location, from different victims. Your bond is presently going to be $3,500. It is a surety bond. You are to have no contact with Gabrielle Richardson and to stay 200 yards away from 3101 Noble Creek Drive in Atlanta, Georgia. If you do make bond, I don't see what your address is. So I'm not going to allow you to return to that location.
No problem with that. You give me my bear.
He has a 3102.
It's Thursday. They don't live there no more. They moved out. They feuded.
I think he's saying, Your Honor, that these alleged victims don't reside at that address anymore, that they have since moved. If that is the case, Your Honor, I would ask that he be permitted to return back to his address.
I will allow him to return back to, I don't know what his address is, Ms. Counts. The
Well, he told me
citation says residentially challenged.
I can only obviously go off of what the client says, and he says that it's 3102 Noble Creek Drive.
Your Honor,
Okay.
if I may, to clarify, when the victim did speak with our victim advocate, they did state that they no longer live at that incident location. But she did confirm that he was a squatter next door. She said that she would be on the Zoom today. However, Your Honor may sound for her if the
I
time.
don't see a Gabrielle Richardson.
And respectfully, Your Honor, I don't know how this individual can confirm unless she's the landlord
Okay.
of this. That's just her opinion.
It's he's got a. Oh,
I'm
there
sorry,
she
this is
is.
the victim advocate.
Yes, Miss Andrews. Good afternoon.
Good afternoon. The police report did also confirm that the leasing agency said that he was a squatter. I'm not sure if anyone could confirm the police report, but it does say on there that he was a squatter, and the victim does no longer live at that address.
All right. Thank you, Miss Andrews.
So confirming that from the
You're welcome.
state, Your Honor, that this alleged victim does not reside there, I would ask that if he's legally allowed to be there, that he would be permitted to return.
And that's the magic word, Miss Counts. He can return to 3102 Noble Creek Drive as long as he's got a valid lease at that property, whether it's through the leasing office or through as a subtenant. But if he doesn't have a valid lease, he's not allowed back into that property.
Understood.
And just to clarify for the record, to verify what our victim advocate stated, the police report does in fact state that he does not have access to that location and is a squatter.
All right. He cannot return to that property if he's a squatter, but like I said, I've got a lot of conflicting information, and the only thing I have are warrants, so that is sworn. So, yes, Mr. Adele.
The land was given to me to do a project.
Mr. Adele, you have the right to remain silent, and anything you say can and will be used against you. This is real life. It's not TV, and I just would strongly advise, based on the fact that you have felony open charges stemming from this event, that you would just let me do my job, okay?
Ms. Counts, I would revisit his qualification for the public defender's office if he's a squatter and residentially challenged. I am not certain about any representation unless you find out who his family is and so forth. But right now, I'm not letting him back into that apartment complex or place unless he is a valid tenant with a proper lease.
Understood,
either
Your
as a
Honor. And
subtenant or-
if in fact he does, a change in circumstances does occur, then he can always reapply to the public defender's office.
All right, okay. All right, Mr. Adele, did you have any questions about your bond?
Not really. She told me not to talk, so I can't talk.
Okay, she'll talk to you later then. And otherwise, make sure you get your own attorney. Thank you.
Thank you.
Position 7, Glenn.
Dominic Glenz is accused of willful obstruction of an officer and battery domestic violence from November 10th, 2022. The case accusation is 22 CR 007733J. And Mr. Glenz, you've been advised of your right to remain silent, and your attorney is going to be Ms. Counts. Ms. Counts, may we confirm?
Yes, he does qualify, Your Honor.
Okay. And Mr. Toussaint,
14 total.
yeah.
Last
14.
arrest was 2021 out of Rochester, New York. Criminal contempt, disobeyed court. Appears to have an unlicensed operation of a motor vehicle, first degree, driving while intoxicated case that's open. I got a 2021 criminal contempt, 2021, that's the license charge. 2015 assault second degree, reckless, cause serious physical injury with a weapon/instrument. That is a conviction. I don't think I saw any other violence besides that one.
Does he have a hold? Is it out of Rochester or? I'm not certain. I'm just looking at the documents on Odyssey. I see an Ontario hold.
Yeah, Ontario County. Yeah, hold on. Let me see. It says limited extradition though.
Okay.
And I believe that's
It's for DUI. Yeah, DUI.
Okay. All right. Ms. Duncan?
Your Honor, this offense did occur yesterday at the racetrack located at 1180 Virginia Avenue in Hateville, which is a part of Fulton County, at about 3:48 in the morning. Officers were dispatched to the location by a person by the name of S. Lindsay. The victim in this case is S. Lindsay. She stated that Shakeela Lindsay, my apologies. SHAKEELA, Lindsay, LINDSE. She stated to officers at that time that they arrived that her and her boyfriend had gotten into an argument that turned physical because she asked another man for a lighter. Once she asked the man for the lighter, she stated that the defendant in this case pushed her into the bushes and started to slam her body on the ground over and over again, and that she tried to escape, and then he grabbed her by her right leg and dragged her back into the bushes and started to punch her in the face multiple times, causing bruising and swelling in her face. Officers indicated that by the time they arrived at that location, the defendant was not on scene. However, they gave the victim in this case a courtesy ride back to a Motel 6 that was in College Park, which is their shared residence at that time at 855 North Central Avenue. It's room 122. They stated that the defendant was there when they approached the residence. He initially refused to open the door against their commands. And then eventually when he did open the door, he was taken into custody. And once in custody, his defendant did refuse fingerprinting. Given the nature of the offenses alleged, Your Honor, we do have some concern in this case about the risk of reoffense. This defendant does have an extensive New York history. We have some concern about flight risk. This defendant is currently wanted. On this case, the state is going to be requesting a $3,500 surety on the battery family violence and a $500 surety on the willful obstruction of a law enforcement officer. We're requesting that there be no further contact with the victim in this case. We are unaware if children are involved in this relationship, but if there are, we'd ask for a third party contact for any children that are available. We'd ask that he stay away from the shared residence that they currently reside in together or any other residence where the victim in this case would reside. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right, thank you. Ms. Counts?
Yes, Your Honor. Mr. Glenn does have a good address of 835 North Central Avenue in Hateville, Georgia. He is transparently, it is an extended stay, but he has confirmed to me that he has paid for this week in full. And so he does reside there. He does have a minor 8-year-old child that he does not pay child support. He is providing full-time care to, and he is in Georgia for employment purposes. And so I would ask for your consideration of a signature bond, if not a signature bond, of low of a bond as possible, so that he may return to his employment matters.
Okay. Is the child here in Georgia or back in New York?
The child is back here in New York. He moved here for employment, and the child was supposed to, once he got settled, follow him, but this has since occurred, which has stalled that plan.
Okay. On the willful obstruction, it's going to be 500. On the battery domestic violence, is going to be 2,000. Total bond is going to be 2,500. It is a surety bond. No further contact with Shaquila Lindsay. He is to stay away from the Motel 6 at 845 North Central Avenue as long as Miss Lindsay still occupies the premises. He may return there one time only with a police officer to retrieve his personal belongings. And then within 30 days, he must update the court with his new contact and address information. No illegal drugs, no alcohol, no weapons. And his next court date is December 1st.
Thank you.
Did you say a 1-day anger awareness?
No, I haven't ordered that yet.
Oh, okay.
Position 4, Carl.
Caleb Carroll is 22 CR 007725C, accused of driving while license suspended or revoked from November 10th, 2022. Mr. Carroll, you've been advised of your right to remain silent, and your attorney is Ms. Counts. Ms. Counts.
He does not qualify, Your Honor.
All right.
And
So
he knows that.
all right. So, Mr. Carroll, after today, you would need to retain your own attorney to represent you, as the public defender's office will not be able to continue representation. Mr. Tucson?
6 total. 2018 arrest out of Alabama for DUI. It was dismissed. Last Georgia arrest was in August. Hit and run, resulting in serious injury or death. Suspended license, DUI. September 2021, disorderly conduct. He got first offender for disorderly conduct in 2016. 2016, maintained a disorderly house conviction. That was out of the cab. That's it.
Thank you. Ms. Duncan?
Yes, Your Honor. In this instance, officers were patrolling the area of Campbellton Road. They observed a black Jeep improperly making a right turn on the Campbellton Road and driving over the curb. They additionally saw the driver make other traffic offenses while observing him, and they pulled the car over on a traffic stop. After activating their lights, when they made contact with the driver, he was identified as the defendant in this case. When they looked at this defendant's GCIT, it did indicate that this driver's license is suspended for FTA. I do want to note for the record, this defendant has an extensive driver's history with at least 26 infractions going back to 1996. 13 of those, I believe, are citations that resulted in suspensions for failure to appear. This defendant does have 1, 2, 3, 4, 5, 6 active suspensions on their license for failure to appear. It indicates that this defendant's commercial status is suspended, as well as non-commercial status is suspended on the licenses that have been provided to this defendant. So here we have an extreme concern about the risk of reoffense given this case and the most recent traffic offenses with the hit and run. Your Honor, we believe that this defendant may be a danger to other motorists on the road, as well as a danger to himself with these driving habits that are indicated by the record as set forth in the GCIC and driving history. There is a preset bond in this case of $1,000 surety. However, given the nature of the offenses alleged, the state is going to be asking for the increase to $2,500 surety because of those multiple suspensions and current recidivist nature of this offense, and no alcohol, drugs, and weapons, no further violations of Georgia law, and no driving. Nothing further from the state.
Where did we get the $1,000 bond from?
It was the preset bond that was listed in Odyssey.
But who posted that bond? If you can find that out for me, that would certainly be helpful.
I
Okay,
don't know, but if Deputy Falk, would you be willing to see if you could find out for me?
okay. All right, yes, Mr. Carroll, we can address you shortly, but I mean, you have a right to remain silent. You want to, what?
I'm sorry.
What did you say?
I would like to speak. When she said that 26 infractions dating back to 1996, I was 2 years old in 1996. And the last arrest with my DUI a few months ago, I hit a parked car. There was no injuries.
It's okay, Mr. Carol, please don't say anything else. Yes, I was gonna correct that. He would have been 2 years old. I don't know what she's reading from.
Okay.
It's from the driver's history. I'll go back and check. As for the $1,000 surety bond, Your Honor, that was the preset bond, but it has not been posted by anyone according to the jail screen. I'm in the bond section. I'm not seeing anyone has posted a bond for that $1,000.
No, I meant who authorized that bond?
Oh, who authorized that bond? I would assume the judge that signed the warrant, which looks to be, I cannot read that signature. So I'm honestly not sure who actually authorized that bond, Your Honor.
Okay. Let's move on. Ms. Counts?
Yes, Your Honor, we could just get a correct recitation of his history for your discretion.
The one I'm
because
considering is the August 2022 hit and run.
Right.
A DUI and suspended license. He had a prior 2018 DUI and a September driver's license issue as well.
Okay, I just want to correct for the record recitation because his date of birth is May 17th of 1994. And so it would have been impossible for whatever cycle the state may have been reading from. Nonetheless, Your Honor, as stated, Mr. Carroll would not qualify for the services of the public defender after today. He does have great employment. He works in supply chain at DHL, and again, due to that income, would not qualify. He has significant ties to the state. He's been here for 22 years, Your Honor. So I would say that despite whatever failure to appear the state again spoke to, he does have significant ties here to Georgia, and has assured me that he will avail himself to court. Beyond that, I do understand the severity of the charges that are akin to driving or driving infractions, violations of the road. And so I would leave it to your discretion on a bond, but would ask for a low of a bond as possible to be reasonable for him to post bond. Thank you.
If I may clarify for the record, his GCIC goes back to 2017. However, what I was reading from was the driver's record that was indicated in the in our Odyssey portal. However, we're verifying that at the time Nonetheless, this defendant still has a very disturbing criminal history with driving infractions that we believe would warrant the $2,500 increase up and above beyond the $1,000 that was preset, I think further from the state.
Bond is going to be set at a $5,000 signature bond through pretrial. He is not to operate any motor vehicle. He'll be subject to random screens for alcohol and illegal drugs. If he does not report to pretrial, if he gets stopped for a driving matter when he's not supposed to be driving, or if he fails a drug test or an alcohol test, pretrial is authorized to revoke the signature bond and convert it to a surety or cash bond only. Your next court date will be sent to you at your address. And we have a Fault Shoals. Is that supposed to be Flat Shoals Road?
Yes, Your Honor, 4483 Flat Shoals.
All right. Mr. Carroll, if you are driving and you get pulled over, just remember when you come back to jail, bring $5,000 with you, because that's how much it's going to cost you to get out of jail next time.
Yes, ma'am.
And no driving, and you have to report once a month to pretrial. And you will be subject to random screens for alcohol and illegal drugs. So from now until all your cases are resolved, you cannot consume either one.
All right.
Happy holidays.
And just to clarify for the record, Your Honor, that driving history does in fact only go back to 2017. So
thank you.
There must have been a misstatement in my
Yeah.
transposition of the dates when I was doing my workup.
No problem.
Hey, that's per judge.
Yes, you can put down per judge, Ms. Grace. Thank you. Next case, Ms. Deputy Francois.
Position 3, Bradley.
All right. Miss, did you say Bradley?
Yes.
Oh, yeah, so sorry. Yeah. Yeah, here it is. Okay. This is Julius Bradley, 22 CR 007723J, accused of battery domestic violence from October 8th, 2021. Mr. Bradley, you have a right to remain silent as you've been advised, and your attorney is Ms. Counts. Ms. Counts, I guess we'll just confirm with you first that he qualifies.
Yes, he does, Your Honor.
All right. And Mr. Toussaint, any priors?
36. History out of Alabama, Mississippi, and Georgia. I'll go with Mississippi first. 2017 trespass, 2011 burglary.
Any battery or ag assault or anything of violence in the last 10 years? Convictions?
No. However, he has a hold for a family offense out of Decatur. And he got an FTA hold out of Cummings.
All right, thank you. Ms. Duncan?
Yes, Your Honor. I just wanted to say for the record that the state is pursuing this case as a felony strangulation upgrade. We received additional information after the felony first appearance cutoff period, but we are going to be seeking that upgrade. But given that today is a holiday, we're going to be arguing for bond, and we just ask that the court grant it commensurate with the nature of the allegations. Because in this instance, it did occur on October 8th, 2021 at 1295 Donnelly Avenue, Southwest Apartment C6. It is indicated in the police report, Your Honor, and the warrant that there was a dispute between the defendant in this case and the victim in this case, which at the time her name was
Corlin Mobley?
Corlin Mobley. Her name has since changed to, one moment. Her name has since changed to Africa Diamond Mobley. It's indicated that at that time, officers responded to a dispute call from Ms. Mobley, and she indicated that her and her boyfriend had gotten into a verbal altercation about her not wanting to be with him anymore. That altercation turned physical, and she stated that the defendant wrapped his arm around her neck, placing her in a chokehold until she was no longer conscious. When she woke up and got up off the floor, she stated that her and the defendant walked back into the apartment and they began to physically fight again. Officers notated that Miss Mobley had blood coming from her nose, a black eye, and her forehead was swelling. Officers
Oh, where do you get the information about that she lost consciousness?
This was information provided to us by the victim herself and in the police report from the officers that responded to the scene.
I see, okay.
And officers were able to have her identify. Officers were able to have her identify the defendant. He was positively identified. In this case, we do have some concern about the risk of reoffense because in addition to what preacher has stated, we did see a 2002 domestic assault violence conviction out of Alabama. We do have some concern about flight risk given that this defendant is wanted in addition to reoffense because there's a domestic offense warrant out as well as the likelihood to positively respond to the legal process. This defendant does have some FTAs out of Alabama and a fugitive from justice from 2021 as well as several probation violations. Given that the victim did state, however, that she did not want to further prosecute these charges, but as Your Honor well knows, we have some concern about intimidation here, given the cycles of violence. Given that he put her in a chokehold, Your Honor, as previously stated, to the point that she lost conscious, we're severely concerned about the safety of this particular victim, and we're looking into the transfer. Therefore, we're going to be requesting a $5,000 cash-only bond. No further contact with the victim in this case. We're unaware if they have children, but if they do, we'd ask for third-party contact. Stay away from wherever the victim in this case resides. If it's the incident location, we'd ask for that location. 2 weeks anger management, no alcohol, drugs, and weapons, and no further violations of Georgia law.
And Judge Law and PD Counts, if I may, if you'll refer to page 3 of the case.
Oh, no, I scrolled down. I didn't.
Right. I just wanted to make sure we were all on the same page. This was actually uploaded unusually as part of the warrant package.
Okay. All right. Mr. Bradley, if you'd like to say something, I would rather you wait till your attorney tells me your side of the case. You have a right to remain silent. Anything you say, your statements can be used against you, and it will be make it very difficult for your attorney to represent you.
Well, Your Honor, I feel like I'm
Mr. Bradley, you have the right to remain silent. And if you have not heard, the state prosecutor just informed us that they are pursuing this as a felony after today. And so I would strongly urge you to please maintain your right to remain silent, because there's nothing that you're going to say that's going to change anything today. But you can't say something that will harm you today.
And also, my apologies, I forgot to add this to my recitation. When speaking to the victim, she did indicate that the defendant has called her from jail. So we further our concerns about intimidation of the witness, given her current state of being in terms of how she wants to pursue this case, but nothing further from the state.
All right, thank you. All right, courtroom 2, Mr. Bradley, I've so advised you of your right to remain silent. Your attorney has advised you. If you want to say something, you have to waive your right to remain silent. Are you waiving that right?
Yes, ma'am. I sure am waiving that right, ma'am.
All right, it's your funeral.
Because, ma'am, first off, the charge that I am here on, I don't know where she's coming from with this, but it has nothing to do with that. From October 2021, I have no out-of-state, no kind of out-of-state warrants at this point. What she talked about is something that is very, very, very old, and what she never did pursue. You know what I'm saying? She just got her name changed, and she's getting her information mixed up. What she's getting her information mixed up is from our address. Where this happened was, this happened on
why don't I show you the warrant? And then I'll explain to you what your situation is, because I have a feeling that the more you speak, that is going to be very, very difficult for any lawyer to represent you and defend you in this case. All right? So if the host will allow me a screen share, please. As soon as I get screen share rights. Oh. Ms. Champion?
Yes, ma'am. I'm trying to
Okay.
locate the screen share information. Can you send me a request? Because it's not coming up on my end.
All right. I think can you pull up this case and just pull up the warrant? Or rather, I'll just read the warrant to Mr. Bradley. Maybe that will help. So, Mr. Bradley, we have a warrant that's been signed off by a police officer and by a judge, alleging that this incident occurred on October 8th, 2021, between you and Ms. Mobley at 1295 Donnelly Avenue. Now, this is their sworn information, all right? The incident occurred apparently on October 8th, 2021, and the warrant was signed on October 25th, 2021, just a few days afterwards. So it's not like someone waited a whole year. It was just a few days. Listen very carefully. Listen very carefully. I'm doing this for your benefit. All right? Now, what the prosecutor is referencing is that along with those documents, the officer also filed his report where he added more information. That is going to give the prosecution the ability to see if they want to upgrade your case from a misdemeanor to a felony. So right now, because this information is stacked against you, it is highly recommended that you don't say anything, that you only speak with an attorney, and that you work with your attorney to prepare your defenses so that your attorney can challenge the evidence that we have presently. But if you say something now, all you're going to end up doing is make it more difficult to represent you, because you're going to make statements that are going to be used against you. All right, let's unmute courtroom 2. Mr. Bradley, I understand you want to maintain your right to remain silent. Would that be correct?
Yes, ma'am.
Smart move. All right. Anything else to add, Ms. Counts? Oh, you're on mute.
Yes, Your Honor, just briefly, Mr. Bradley does have a good address of 1401 North Harrison Road, and that is in Stone Mountain, Georgia. He does have a 7-year-old child that he does pay child support for, a nice amount of child support for, and does need to return back to receive employment in order to continue paying that child support. I do understand the recitation of his criminal history is definitely within your consideration for a signature bond, or to not give him a signature bond, but I would ask for a low of a bond that's reasonable for him to be able to bond out. Nothing further.
Bond is set at $3,500. It is a surety bond. No further contact with Africa Diamond Mobley, formerly known as, was it Christian Mobley? Corlin Mobley. And to stay away from wherever she happens to live, work, standing, you just have to stay 200 yards away from her. No alcohol, no drugs, no weapons. And your next court date will be December 1st. If the state does get a transfer to the to the Superior Court as a felony matter. Miss Falk or Miss Duncan, if y'all do that within the next 12 hours, can you please file the appropriate paperwork so he can get his felony first appearance tomorrow? I don't know who's going to be the judge tomorrow. So
we will. I have already sent that email to the DV unit to review and for their approval. I've not heard back yet. Obviously, it's a holiday, so I'm not sure if they will get back to us in time.
okay. All right. Thank you.
And Your Honor, what is the first name again of the new first name?
I had Africa Diamond Mobley.
Okay, thank you.
All right, next case, Deputy Francois.
I'm gonna talk to you later.
I'm sorry, Francois, who do we have?
Position 13, Shear.
All right.
I'll represent Mr. Shearer today, Your Honor. He does qualify.
Okay, thank you, Ms. McLean. Mr. Eugene Shearer is charged with simple battery domestic violence from May 6, 2022. And Mr. Shearer, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. Any priors, Mr. Tucson?
15 total. 2012 criminal damage to property, second degree conviction. Yeah, the 04 simple battery. It just says merged. 2005 failure to appear for dog fighting, not prosecuted.
Okay.
2008 theft by taking auto. Yeah, that's
All right. Ms. Anderson?
Your Honor, before I give you the bond, I also see a 2009 simple battery arrest, but I don't know the disposition of that as well. The state is asking for a $3,500 surety bond, no contact with the victim, Shavi Sharer. I believe I'm pronouncing it correctly, but it's spelled C-H-A-V-I, Sharer. No alcohol, drugs, or weapons, a one-day anger awareness class, and a stay away from 8195 Autumn Green Drive. Your Honor, on the date of offense, the victim, Mrs. Scherer, was in the family home's backyard when, unprovoked, Mr. Scherer came out and poured water all over her and used expletives to communicate with her, began to argue with her. She went inside the family home where he followed behind her, and once in the kitchen, he grabbed her by her hair, pulled her down to the ground, and began dragging her on the floor by her hair. Our victim's advocate has been able to speak with the victim today, and she said that once the children spoke to the defendant, he was able to come to his senses. She also stated that he does this stuff to be mean and takes it out on her, and that she only called the police so that he could get out of the home and get away from her. Though the victim chose not to be present today, it does appear from her statements that this is an ongoing issue, and that is the reason for the $3,500 surety bond, Your Honor, and the stay away from the family home.
All right. Mr. McLean?
Your Honor, this took place in May, and whatever happened in May in the way of an argument, he was recently arrested, and there were no communications within the family, not with the son who was mentioned in the report, not with the wife. There was no communication to him. You would think they would have a discussion if they would inform him the police were called and there might be a warrant out for his arrest. They've been
as long as I've been
together.
doing this, I'm not surprised by that anymore. That they
Right.
do not have conversations.
They don't want to have conversations about
They
it.
don't. I'll be shocked if they have a conversation. Oh, honey, by the way, there's a warrant outstanding against you. No.
Or there might be.
Yeah.
In this case, or there might be. So if I would not agree completely with the statement of the state, I would not agree that it appears that this is an ongoing problem, because there have been 6 months of silence and quiet in this situation. So we would ask the court to consider a signature bond in an amount, well, an appropriate amount, but I don't think there have been any further incidents in the last 6 months.
All right. With regards to Mr. Shura, your bond is going to be set at 2,000. It's going to be a surety bond. You're to have no further contact with Shabi Shura. You're not to return to 8195 Autumn Green in South Fulton. You may return one time only with a police officer to retrieve your personal belongings. And within 30 days of being released from your bond, you have to update us with your new address. Your next court date is going to be December 1st. No alcohol, no drugs, no weapons, and no firearms. And please be mindful to comply with the conditions of the bond. You cannot return and live with Mrs. Shura until you get a court order that says you may do so. Thank you.
Thank you.
Can you repeat that one more time, Your Honor? I'm sorry.
Okay, $2,000 surety bond. Reset date December 1st. No contact with Shabi Shura and stay away from 8195 Autumn Green in South Fulton. He may return one time with a police officer to retrieve his belongings, and he must update the court with his new address within 30 days of release.
Thank you.
All right. Francois, yes?
Position 8, Grant Bolden.
This is Mr. Christopher Grant Bolden, accused of theft by taking from November 6, 2022. Mr. Bolden, you've been advised of your right to remain silent, and your attorney is Mr. McLean.
It's me, Your Honor.
Oh, Ms. Counts, okay. And we are confirming representation by the Public Defender's Office, yes?
He does not qualify, Your Honor. It has been informed.
Mr. Grant Bolden, you would need to retain your own attorney after today's proceedings, okay? Mr. Tucson?
10 total. He got 2 open bench warrants out of state court. It's simple battery and battery. Both cases got the same, both charges got the same case number, 20 CR 000-217B. It's $1,000 on each one of those. 2011 theft by taking conviction. 2012 probation, underlying charges burglary. He got first offender for that in 2011. 2010 theft by taking, driving without a valid license. That's it.
All right, Ms. Duncan?
Yes, I also see a probation violation in 2014. That was a guilty conviction. In this case, Your Honor, it did occur at 439 Edgewood Avenue Southeast in Atlanta, which is either the municipal market or the smoke shop. But in this case, the defendant was an employee of that location. Officers received a call to respond due to a theft. They met with Miss Bailey Flattery, that's BAILEEFLAHERTY, who is the operations manager. She stated to officers that her accountant indicated to her that the seal had been broken on a plastic deposit bag that had been delivered to them, which initially indicated that there was an amount of $529 inside. However, upon opening the unsealed bag, there was only $329. It is indicated from video surveillance that the defendant was seen in this case taking possession of that sealed bag from another co-worker and waiting until that co-worker left, opening that sealed bag and taking about $200 in U.S. currency and leaving the location. In this incident, Your Honor, once the defendant was apprehended, he was taken into custody. He was Mirandized, and officers asked that he would like to speak to them without a lawyer. And he stated to officers at that time, after being Mirandized, that he stole the money because he had recently lost his apartment, and he was not making enough to pay his bills at that time. So here we have some concern about the risk of reoffense, given that this defendant does have prior theft by taking convictions, and we did see a 2010 theft by taking arrest as well. However, it was dismissed. We do have some concern about flight risk, given that this defendant does have a recent FTA, as well as 2 open state court cases. Your Honor, given the facts and circumstances and the other factors that we believe are present in this case, we believe that a $2,000 surety is more than reasonable. No further contact with the operations manager of that facility, name as stated on record. Stay away from that facility as stated on record. No alcohol, drugs, weapons. No further violations of Georgia law and a theft class.
Mr. McLean?
No, it's mine,
Oh,
Your
Ms.
Honor.
Counts, sorry.
Yes,
I'm sorry, your video is on and Ms. Counts is off. So I'm sorry, I keep calling you. Sorry about that. Ms. Counts, yes.
Yes, Your Honor. Mr. Grant Bolden does have a good address of 1401 North Harrison Road in Stone Mountain. He has informed me that he is employed as a construction worker. So I guess this is a separate and apart employment than what the recitation was. And so based on that, he would not qualify for our services going forward. I have informed him of that, Your Honor. I would just ask for, in consideration of his criminal history, of a lower bond as possible.
All right. On the theft by taking is going to be 1,500 surety, and to stay away from the municipal market at 439 Edgewood Avenue in Southeast Atlanta, Georgia. He does have 2 other open cases, and both these cases will be placed on the SAP calendar along with this new one. I'm sorry, Ms. Grace, do you see the 2 cases listed on the calendar for position 8?
Yes, Judge.
All right, so we'll put all 3 cases on the SAP calendar for December 1st. Mr. Grant Bolden, if you do make bond in this case as well as bond in the bench warrants and your other 2 cases, then you will be responsible for making sure you stay away from that location and that you update the court with your new address as soon as possible.
Yeah.
Ms. Counts, if you have that new address in Stone Mountain, could you put it in the chat to Miss Melissa Grace, LM Melissa Grace?
Yes,
we'll make
Your
sure,
Honor.
because we don't have that new address on file.
Yes.
Okay. All right, anything else? Francois?
We're completed here in courtroom 2, Judge.
All right, thank you.
All right, thank you.
I don't think I have a South Annex, so I'm just going to go down the calendar. Position 1, Adele is 3,500 surety, reset December 1st. Position 2 is $1,000 surety, reset December 1st. Position 3 is 3,500 surety, reset December 1st. Position 4 is Mr. Carroll, and that's going to be a $5,000 signature bond through pretrial services. No driving. Yes, Ms. Grace, please make sure you put that for Judge.
Your Honor,
And
can you state
yeah,
the other conditions for position 4?
position 4 was no further contact with Africa Mobley, stay away from wherever she lives, no alcohol, drugs, and weapons.
Position 4, that's Carol.
Oh, 3, sorry, Carol. Position 3 was no driving, and he has to report to pretrial once a month and random screens for alcohol and or illegal drugs.
Thank you.
Position 5 is 1,500 surety, reset December 1. Position 6, Gaskin, $1,000 surety, December 1. 7, Glenn is 2,500 surety, December 1. Position 8 is Grant Bolden. The bond is 1,500 surety, December 1st. Position 9 is 2,000 surety, reset December 1st. Position 10 is $1,000 surety, reset December 1st. Position 11 is a 3,000 signature bond through pretrial, further notice. Position 12 is a 6,500 surety, 6,500 split bond. It's a 5,000 surety and a 1,500 signature bond through pretrial.
For Judge.
Yeah. Position 13 is a 2,000 surety bond, December 1st. 14 is a 2,500 surety bond, December 1st. 15 is a 1,500 surety, December 1st. And 16 is a $1,000 surety, December 1st.
I'm sorry, Your Honor, you said 15 is a what?
I had 1,000.
I have 1,000
For which one?
for 15.
15?
Correct.
Okay, all right, we'll go with 1,000. I'm sorry, my
And
zero
then the
looks like a
same,
pi.
this-
Sorry.
this- and then the
And
same
position
for,
16 is, go
is
ahead.
for the 16, I had 1,000 as well.
Yeah. Isn't what I said? 1,000 surety?
Yeah, you got that one right.
Oh, I got that one right. Okay. Okay.
Thank you.
All
Judge.
right, folks. I think that concludes our calendar. I'll see you tomorrow at 2:00. Take care, everyone.
Thank you,
Have a
Judge.
good
Thank you, Your
Friday.
Honor.
Bye-bye.